Good afternoon. I'm Elaine Alston, and I've been an attorney for nearly 34 years. I have represented landlords, both commercial and residential. I've also represented a large number of mobile home park owners. I have handled a few cases for tenants, both in the residential and the commercial aspects. I also do estate litigation and other business types of litigation. Today, we're going to be talking about some of the new laws and updated laws regarding landlord-tenant relationships. Our firm, Copenbarger and Copenbarger LLP, has a number of attorneys available for a variety of needs. We are a well-rounded law firm. We have jointly or commutatively hundreds of years of experience. And we can't do the work that we do without our staff. And this is a slightly older picture of the staff that work for us. We're real pleased to have everybody here. They will assist everybody with regard to your legal matters. We also have locations throughout the state of California. Our main office is in the South Coast metro area of Santa Ana, and that's where I'm speaking to you from today. But as you can see, we have offices in San Jose, Temecula, San Diego, Sacramento, Pasadena. Today's agenda, we're going to start with just talking briefly about rental agreements. We'll move into security deposits, notice to tenants, and of course, the ever difficult calculation of cure periods. Rental agreements. The rental agreement, along with the laws, shape the relationship between the landlord and tenant. The rental agreement defines the obligations and duties of each party, and it is signed by both the landlords and the tenants. The rental agreement determines who can live on the premises, determines who will pay the various expenses that arise with respect to owning real property. The rules and regulations that landlords want the tenants to abide by can either be literally part of the rental agreement, or they can be in a separate document and incorporated into the rental agreement. The rental agreement can warn of dangers. It can require disputes to be handled by arbitration. Handling a dispute by arbitration will avoid a runaway jury. It avoids publicity. It can be less expensive, and it can be resolved faster for civil matters. Now, eviction cases are much better handled in the unlawful detainer arena of the court system. Evictions under unlawful detainer actions are much faster. So many times the rental agreements will have that certain disputes will be decided and determined by arbitration, but termination due to fault or no fault can be handled through an eviction process in the court system. If you have questions about the arbitration versus court cases, please talk to your attorney, as there are many pros and cons for each of those. Now, the rental agreement will also discuss what can be used for the property, whether or not the property can be used as a daycare facility or used for business purposes, whether or not poisons can be stored on site, whether or not the tenant can repair automobiles on the site, and of course, the storage of hazardous materials. And in talking about hazardous materials, we're not talking about the small cleaning supplies that a tenant might have. We're talking about storing large amounts of cleaning supplies on the property. You should, as a landlord or a tenant, be sure that you know the terms of your rental agreement. Read the whole thing. Make sure that you understand the entire agreement. If you don't, then either ask for clarification, ask an attorney, get it clarified as part of the agreement, but make sure that you don't sign it if you don't understand it. If a rental agreement is properly prepared, it should be very clear as to who has which particular obligation. It will protect both parties in disputes, and quite frankly, it ensures a good relationship. The next area is a brand new law that's just come out. We had a security deposit law for many, many years. We had a change that became effective on January 31st, 2024. Then it was changed again on July the 1st, 2024, and then again on September 19th, 2024. At the present time, there are not any bills before the Congress to change that. So hopefully our security deposit law, as currently written in the state of California, will be the law. It is significantly different from the older law. The intent of the new law is to ensure that landlords do not subsidize improvements to their rental properties with a former tenant's security deposit. Most landlords can only charge a sum equal to 1 month's rent, regardless of whether the property is furnished or unfurnished. There is a small exception, and that is if the landlord is a natural person or a limited liability company. And a limited liability company must have all of its members being natural people. The limited liability company or the natural person cannot own more than 2 residential properties with no more than a total of 4 dwelling units. Natural persons include a family trust, but the settlers of that trust must, and all the beneficiaries, must be related as either siblings, spouses, domestic partners, parent, grandchildren, and grandparents. Basically, they've narrowed that exception to very, very small amounts of people. So again, you should anticipate not being able to collect more than 1 month's rent as a deposit. Now, the security law says that a landlord shall not assert a claim for damage that pre-existed the tenancy. Ordinary wear and tear or effects of cumulative wear and tear are excluded. The amount of the claim for materials, supplies, and labor performed by either a contractor, the landlord, the landlord's employees, shall be limited to a reasonable amount necessary to restore the premises back to the condition it was in at the inception of the tenancy, exclusive of ordinary wear and tear. The landlord is no longer allowed to assert a claim for professional carpet cleaning or other professional cleaning unless reasonably necessary to return the premises into the condition it was at the inception of the tenancy, exclusive of ordinary wear and tear. This basically means that you can't automatically just go in and have a professional company come in and clean the carpet and bill that to the previous tenant. Now, if the tenant had stained the carpet, perhaps had a pet, and there were a number of pet stains, then you could have it professionally cleaned and request those funds. But again, it cannot be done just automatically. The security law now provides that the tenant shall be notified of their rights to have an inspection not earlier than 2 weeks before the end of the tenancy. And the purpose of that notification is so that the property can be inspected and the tenant provided a list, an itemized list of everything that needs to be repaired so that the tenant can cure that deficiencies prior to the end of the tenancies. So the landlord must give the tenant notice that they're entitled to have an inspection not earlier than 2 weeks before the end of the tenancy. If the tenant elects to have an inspection, the landlord must give 48 hours notice of that inspection time. If, however, the landlord and tenant can agree upon a time for the inspection, then both the landlord and the tenant in writing may waive the right to that 48-hour notice. But again, make sure that if you've agreed upon a date and time for the inspection and it's less than 48 hours, that there is a writing that says, we agree to this time frame, to agree to do it January 1st at 2 o'clock, and we as the landlord and tenant are waiving the 48-hour notice. Now, the notice, the landlord may proceed with the inspection, whether or not the tenant is present or is not present, if the tenant has so requested the inspection. There is a required notice that must be given, and the notice must state as follows. State law permits former tenants to reclaim abandoned personal property left at the former address of the tenant, subject to certain conditions. You may or may not be able to reclaim property without incurring additional costs, depending on the cost of storing of the property and the length of time before it is reclaimed. In general, these costs will be lower the sooner you contact your former landlord after being notified that property belonging to you was left behind after you moved out. The inspection, the landlord shall give the tenant an itemized statement specifying the repairs or cleanings that are proposed to be the basis of any deductions from the security the landlord intends to make pursuant to, and there's sections, paragraphs 1 through 4 of the code section. The statement is required to state those sections verbatim. And those sections are the compensation of a landlord for a tenant's default in the payment of rent. 2, repair of damages to the premises, exclusive of ordinary wear and tear caused by the tenant or guest of the licensee. 3, the cleaning of the premises upon termination of the tenancy necessary to return the unit to the same level of cleanliness it was in at the inception of the tenancy. The amendments to this paragraph enacted by the Act, adding this sentence, shall apply only to tenancies for which the tenant's right to occupy begins after January 1, 2003. 4, to remedy future defaults by the tenant in any obligation under the rental agreement to restore, replace, or return personal property or appurtenances exclusive of ordinary wear and tear, if the security deposit is authorized to be applied thereto by the rental agreement. This statement shall be given to the tenant if present, or left for the tenant if the tenant is not present. Again, those are required statements in the law, so they can't be varied. They have to be the exact language that comes out of the statute. Our firm has forms if you wish to contact us for copies of those forms. But again, it comes straight from the code section and you must have it in there. If the initial inspection is conducted and at the time of the inspection, the premises do not contain tenant's possessions that prevent the landlord from identifying repairs or cleanings due to the presence of those possessions, the landlord shall not include any repairs that were not identified in the itemized statement. Essentially, what it amounts to is if a tenant has a couch and they place the couch over the huge stain or tear in the rug, then at that point in time, when the tenant's possession is moved, the landlord now sees the big tear or big stain and can say, we had to clean where your couch was and provide for the damages. But if you went into the property and the room had no furniture in it, if you failed to list the tear in the carpet, you're not going to be able to ask for the tear in the carpet to be repaired at the cost of the tenant. Landlord can use the security for those itemized repairs or cleanings not cured by the tenant. landlord can use the security for any of the 1 through 4 reasons that occurs between the inspection and the final inspection, or those things that the presence of the tenant's possessions prevented discovery. This essentially means that if you go into the apartment and it's fine, everything looks good, the toilet and the tub are good, and then you go in after the termination and you find that they took a sledgehammer to the toilet and it's broken, yes, you're entitled to get the damages for the toilet. But again, if it's something you just missed on your walkthrough, you're not going to be allowed to do it. And the theory and the rationale is that the tenant is supposed to have a period of time to cure. So if the tenant was notified that the rug was very dirty, then the tenant could decide they're going to buy some carpet cleaner and clean the rug and make it presentable. Starting on April 1st of this coming year, 2025, landlords shall take photos of the unit within a reasonable time after possession is returned prior to repairs or cleanings for which the landlord will make a deduction, and shall take photographs of the unit within a reasonable time after such repairs and cleanings are made. Basically, this means that beginning April 1st, the landlord will have a record of what the place looked like at the time the tenant vacated, and then what the premises looked like after they repaired it. So that they can show, essentially, if there's a challenge, that they did make the repairs that they were deducting for, and that the tenant did leave the premises in a condition that was inappropriate and needed to be repaired. Beginning in July 1st, 2025, the landlord shall take photos of the unit after the inspection of the tenancy. I would suggest that you start now taking photographs of any unit that you are going to rent to a tenant. Get yourself in a habit of doing it, because come July 1, the law says you shall, not may, but shall, which means it is a requirement. So it would be easier to start getting people to do that earlier. There's no harm in doing that, taking the pictures so that you can then document that this is what it looked like. And then when you've got your pictures of what it looked like when they vacated, you can certainly show at that point in time the difference in what needed to be repaired. Now, 21 days after the tenant has vacated, but not earlier than the time that either the landlord or the tenant provides notice to terminate the tenancy, or not earlier than 60 days before the expiration of fixed term of tenancy, the landlord shall furnish the tenant by personal delivery or by first-class mail, postage prepaid, a copy of an itemized statement indicating the basis for the amount of the security received, the disposition of the security, and shall return any remaining portions of security to the tenant. Now, the tenant and landlord may agree to use email and electronic deposit if they want to, but that agreement needs to be in writing. If the landlords or the landlord's employees did not perform the work, the statement shall describe the work, the time spent, and the hourly rate, and provide a copy of the bill, invoice, or receipt by the person or entity that did the work. The statement must include the name, address, and telephone number of the person who did the work if it's not on the invoice, bill, or receipt. In other words, the tenant has a right to see who did the work and what the bill was, and can contact them by giving them the name of the address, the name of the person, and their phone number, so that they can check and make sure that, as far as they're concerned, that all that was done was the repair of the property to bring it back to the condition it was at the inception of the tenancy, with the exception of ordinary wear and tear. If the landlord or the landlord's employees did the work, the statement shall describe the work, the time spent, and the hourly rate. If deduction is made for materials or supplies, that the landlord shall provide a bill, an invoice, or receipt for those supplies. If a particular material is purchased by the landlord on an ongoing basis, the landlord may document the cost of the item by providing a bill, invoice, receipt, vendor price list, or other vendor document that reasonably documents the cost of the item used in the repair or the cleaning of the unit. If a deduction is made for repairs or cleanings, the landlord shall provide photographs along with a written explanation of the cost of allowing repairs or cleaning. Mail, email, computer flash drive, or providing a link where the tenant may view the pictures is required by the statute. This means the tenant has to be given access to the photographs taken of the repairs being made. If a repair cannot be reasonably done within 21 days by a landlord or landlord's employees, or if the documents from a person or entity providing the service is not available within the 21 days after the tenant vacated, the landlord may deduct the amount of a good faith estimate of the charges that will be incurred and provide that the estimate with the itemized statement. If the reason for the estimate is that the landlord does not have possession of the document from a third person, the name, address, and telephone number of that third person must be provided. Within 14 days of completing the repair or receiving the documents, the landlord shall provide those to the tenant. If the repairs and cleaning do not exceed $125, the landlord does not need to provide the documentation. The tenant may waive the rights in writing if they sign a notice of termination. But again, that's a requirement that they must sign in writing a knowing waiver. However, even if they have waived and the tenant makes a request for documentation within 14 days after receiving the itemized statement specified in earlier, the landlord shall comply within 14 days. Now, a question that comes up a lot is what happens if you don't know the tenant's new address? The code is very clear. It says mail is to be sent to the tenant at an address the tenant provides. If no address is provided, then it's to be sent to the unit that the tenant has vacated. The law also provides very clearly, and I want to emphasize it, the landlord shall not be entitled to any amount of security if the landlord in bad faith fails to comply with this subdivision. So again, if you're not complying, you won't be able to entitle to any of the security deposit. The security law also discusses what happens if the landlord's interest in the property is terminated. The landlord or the landlord's agent shall have a reasonable time to take certain actions with respect to the security. And if the landlord does so now, former landlord shall relieve the landlord of further liability. But if the landlord does not, the former landlord and the new landlord may be jointly and severally liable. Basically, I'm going to tell you, if you're selling your rental property, make sure that you put as part of the agreement what is going to happen with respect to the security deposit. If you don't turn the security deposit over to the new landlord, then you may still be responsible for returning the security deposit to the tenant. So again, you look at the statute, talk to an attorney, but make sure if you're disposing of real property in which there are security deposits held, that you make sure that's part of your sales agreement. Now we get to the part where the rental agreement has been breached. And we're going to give a tenant a notice demanding some type of a cure. In giving a notice, you need to name all of the tenants who are 18 years and older, and that would include all approved subtenants. If it's a failure to pay rent, be sure to set forth the rental rate, the period of time the rent is outstanding, and the amount of rent that is outstanding. The figures and the dates must be accurate. I've seen landlords lose unlawful detainer actions because they've overstated the amount of rent owed by a few cents. It has to be accurate. The law takes the position that if the amount is overstated, that the tenant, having failed to pay, may have failed to pay because they didn't have the extra amount. So therefore, the amount that you're asking for in the notice must be accurate. Don't include anything in the rent that is not rent. Note that your rental agreement may define what is rent. So if you look at your rental agreement and it says that defined in rent includes a certain utility, then that certain utility bill can be included as part of the rent. But again, don't include the cost of having the pool cleaned if under rent, the cost of having the pool cleaned is not part of the rent. If you're demanding a cure other than failure to pay rent, again, you need to name all the tenants over 18 and all approved subtenants. You need to identify the rule or the covenant, i.e. the paragraph or terms of the rental agreement that you contend are being violated. The best practice is to quote that language so they know where it says you are storing hazardous items. If you place down the section from the rental agreement that says you may not store items that are hazardous to human and pets or whatever. So you want to make sure that you quote the language. You need to make sure the tenant knows how to cure. So your notice needs to tell the tenant what they can do to cure the notice. I.e., if you're telling them that that they need to maintain the front of the property, you need to tell them that they need to mow the lawn. Or if you're complaining that they've got debris or things stacked up on the driveway that aren't to be there, you need to tell them to remove the boxes, to remove the lumber, to remove the trash can, the items. The more itemized you can be as to what they can do, the better off you are. The notices to cure are, again, dependent upon the rental agreement. So if your rental agreement says that they shall have 10 days to cure a defect with respect to lawn maintenance, then your notice has to say they have the 10 days. Now, certain things are dictated by law in the sense of this. If you wish to evict a tenant, and even if your rental agreement said that you could give them a notice of default on rent and they would have to pay within 1 day of your notice, the law says that they have to have 3 days. So in drafting your notices, look at your rental agreements. If the period is longer in your rental agreement than what the law provides for, you need to give them the longer period, or you're in violation of the rental agreement. But if it's a period shorter than what the law provides, you will not be able to enforce it unless you've given them the period provided by the law. Now, there are two types of notices of termination. One is a 30-day notice and one is a 60-day notice. A 30-day notice, with very few exceptions, can only be given to tenants who have not been occupying the premises for a year. 60-day notices are the period of time which you have to give to residents who reside in the premises for more than 1 year. Now, there's some question about where you have a different tenant that comes in over the period. So you have to look and say, is it the same tenant that's been occupying it for 12 months or longer? If it is, then they get the 6-day notice. Now, if adults are added during a tenancy, all must be there for 12 months before you have to give a 60-day notice, or one of the tenants has to have been in possession for 24 months. This is usually where people have rented to a number of tenants, perhaps college students, and they have one person staying for 18 months, another person comes in and stays for 6 months. At that point in time, they can still give a 30-day notice to terminate everybody in the premises. However, if one of the people living in the home has been there more than 2 years, then it's a 60-day notice. That person has to have 60-day notice, and that means everyone in the household has 60-day notice. Under the law, which is relatively new, there is only 2 kinds of termination notices. It requires just cause, and there's a no fault and a fault. Now, a fault, if the tenant is at fault, it's perhaps a failure to pay rent, a violation of a lease term, they're causing a nuisance, they're causing waste on the property, they're subletting when they're prohibited from doing that, they're engaged in criminal activity, they have an unlawful use of the premises, and by unlawful use of the premises, that can also include things that were not provided for in the rental agreement, i.e. prohibited by your rental agreement. They can be terminated because they refuse to let the landlord into the premises for inspection. They can be terminated to refusal after having been given notice. It's also used for employees who are occupying a home pursuant to their employment. When they have been terminated, they're required to vacate, and if they don't, then they're provided a notice, which is a fault notice. Then there's the no fault provision, and this is where the landlord wants to remove the rental property from the market, or if they're complying with a government order to close down a rental unit, if they intend to demolish or substantially remodel the unit. Now, substantially remodeling the unit does not mean you're going to just paint it, because painting can be done in less than 30 days. What the law says is the substantial remodeling must require the tenant to be out for at least 30 days, and generally redecorating, painting are not substantial remodeling. So you're looking for, if you're taking out a wall, you're remodeling a kitchen, it's going to take 3 or 4 months, then you can terminate on that basis, but not just to have new carpet put in. You can also give a termination notice because the landlord wants to have a member of their family live in the unit. And the family is limited to the owner, the owner's spouse, the owner's domestic partner, the owner's children, grandchildren, parents, and grandparents. It doesn't say cousins and nieces and nephews. It's the owner, the owner's spouse, domestic partner, owner's children, grandchildren, parents, and grandparents. And if you want to take it off because you want somebody in your family to live there, there cannot be another similar unit that they could move into, and your family member cannot already occupy a unit. Now, the new law with regard to evictions and the fault and no fault requires giving 2 notices. So if you give a notice to cure because they are in violation, then you're going to have to give a separate notice to terminate for failure to cure. It used to be that you would have a notice that said 3-day notice to pay rent or quit, and 30-day notice to terminate tenancy, which would provide in the body of the notice saying that you had 3 days to vacate, and if you don't, you have to be out in 30. Whereas now there will be a notice that says notice to cure. They'll have 3 days. If they don't cure, then another notice will be given to them informing them that they have to vacate the unit. Now, in the situation where you have no fault, where you're asking the tenant to move out because you want to demolish the unit, you want to take it off the market, you want to put a family member in there, you have to give the tenant 1 month's free rent. You must give relocation benefits, which amount to 1 month's rent and 15 days notice. No fault notices where you're, again, putting somebody else in there, demolishing it, must state why you're doing it. So in other words, the tenant needs to know whether or not you're going to substantially remodel, whether you're going to demolish, or whether you're putting a relative in. If you're going to put a relevant in, the tenant is entitled to the name and relationship of the person you're putting in there. And upon their request, proof of the relationship, and a notice that says the right to relet the premises if the person does not move in within 90 days and remain there for 12 months. And if the person doesn't remain there for 12 months, the tenant can come back and move back in. So again, the person moving in, that you're moving in, must do so within 90 days and must live there for 12 months. When the premises are substantially remodeled, they're entitled to a description of remodel or demolition, copy of the permits, and if no permits, then the contract for which was under it. I have a couple of questions. These relate back to the security deposit. Somebody has asked, can this security deposit be used to compensate the landlord for back rent that hasn't been paid? And the answer is yes. The next question is, does the renter's insurance pays the damage to the apartment and the apartment below? For example, the toilet overflowed and water ran into the apartment below. Will the renter's insurance pay for the damage in both apartments? That really depends on what the terms of the insurance agreement are. Normally, that would be covered. But again, that's something you need to take a look at the actual policy itself. The next question is, if we are transferring the property to our kids through a quitclaim deed, what should we do for the rental agreements? If you're transferring rental property to your children through a quitclaim deed, you need to provide that the children, if they're taking it over, are going to pay and hold the security deposits and be responsible for them. If you're going to continue to be responsible for the security deposits, then you need to say so with respect to the children. We're going to move on now to the calculations of the cure periods. And this gets confusing, and I recognize that it is confusing. A cure period is the time that is provided to a tenant to cure a default. Some cure periods are dictated by law. The cure period for a failure to pay rent is dictated as at least 3 days under the law. The cure period can be dictated by your rental agreement, so you need to check that place as well. In order to proceed with an eviction under the California Unlawful Detainer Statute, the tenant must be given, at the very least, the amount of time set forth in the statute. Under California law, a tenant must be given at least 3 days to cure the default in payment of rent, or to cure a default in covenants. It's one of the terms. It does not matter if your rental agreement provides for a shorter period. You cannot evict the tenant without giving the statutory minimum period to cure. If your rental agreement provides for a longer period of time to cure, you will be required to give the tenant the longer period of time to cure the default. Thus, if your rental agreement states the tenant will have 10 days to cure the default with respect to, say, lawn maintenance, the landlord will have to give a 10-day notice to cure the lawn maintenance, not merely 3 days. Once it has been determined how much time must be given, then we have to figure out the period of time for the cure. A tenant must be served with the document. The term serve is a legal technical term for complying with the law as to how to give the tenant notice. The law provides specific methods for giving a tenant notice. One is to personally hand the notice to the tenant. That's an easy one. That's known as personal service. Then you can hand the notice to a person of suitable age at the premises and mail a copy of that notice to the tenant. So if you go to the house and the tenant's there, you hand it to them. If you go to the house and you knock on the door and a 3-year-old answers it, you're going to have to do a different process. But if somebody 18 or appears to be roughly 18 answers the door, you can give them the notice, but then you have to go and put the notice in the mail to the tenant. The third option, if nobody answers the door or if the 3-year-old answers the door, you post the notice in a conspicuous place and you mail it. Now, people ask, what does it mean to say post in a conspicuous place? That does not mean put it in an envelope and slip it under the rug. It means you take the notice and it's straight out, not in an envelope, not folded up, and you tape the notice straight onto the front door, a back door, a front window, somewhere where a tenant coming to that house should be able to see it. So if you can tell that a person never uses their front door, you barely can get to the front door, then posting it near the front door is not going to be a conspicuous place. So if they have a side door that is clearly used, then it should be posted there. Now, if your rental agreement requires notice in addition to that, or at least in a different manner, you must serve it one of the ways provided by the law: personal, substitute, or posting. And then you must give the notice by whatever your rental agreement requires. For instance, if your rental agreement says they shall be given notice by email, you need to, in addition to personally handing it to a tenant, you need to email it. Now, service is completed at the time that the last act is done. So in other words, if it's a 2-part notice, such as service, such as you have to post and mail, it will not be complete until it is mailed. So when the last act is completed, that's when you can start the calculation process. So if you personally hand it to the tenant, there's only one part to be done: personally hand it to the tenant. If you're required to send it by email, then when you send the email to the tenant, if that's the last act, we'll cover it. If you're handing it to a person of suitable age and you're mailing it, again, the last act would be the mailing. If they occur on different days, you have to use the second day. Now, service is completed, as I said, as the last act. So if the notice is posted on Friday, but not mailed until Monday, the counting cannot start until Tuesday. The last day, the day you actually do the act, is never counted. So the day you hand it to the tenant is not counted. It doesn't matter whether you hand it to them at 7:30 in the morning or 7:30 in the evening. You can't count that day. You cannot have a notice expire on a holiday or on a weekend. So if a 3-day notice is posted on Monday and mailed on Tuesday, the counting starts on Wednesday, day 1, Thursday, day 2, and Friday is day 3. So the cure period would end at Friday at midnight. Now, if a 3-day notice is personally handed to a tenant on Friday, the counting starts Saturday, day 1, Sunday, day 2, and Monday, day 3. The cure period would end at midnight on Monday. You count the weekend days, but if the last day was to fall on a weekend, then it would not count. So if a 3-day notice was handed to a tenant on Thursday, Friday would be the first day, Saturday would be the second day, but because Sunday is a weekend, the notice would expire and the cure period would be over at midnight on Monday. Now, for example, holidays, again, if the last day it falls on is a holiday, you go to the next business day. So if a 3-day notice was served on Monday, July 1 by personal service, the counting starts July 2, day 1, July 3, day 2, but because July 4 is a holiday, that day would be skipped. So the 3-day notice would expire at midnight on Friday, July the 5th. Now, there has been some questions about whether or not because you mail a notice, whether they get additional time. Under the law, there's a provision that if you're in the middle of a lawsuit and a document is served by sending it through the mail, that people get additional time because it was sent through the mail. Well, there's 2 cases. One, Walters versus Myers, which was decided in 1990, that said a 3-day notice does not get any additional time merely because it was mailed. And then Highland Plastics Inc. versus Endeavors from 1980 said that a 30-day notice does not give extra time. So again, the fact that you mail it doesn't give them any extra time than if you personally hand it to them. You just count from the last day from the act, and mailing is deemed mailed the day you put it in the mail. So you start counting the next day after you've mailed the act. And when the notices expire, it is time for an eviction. And at that point in time, the landlord will proceed in court by serving a complaint upon a tenant and perhaps engaging in discovery, and ultimately there will be an unlawful detainer action actually hearing, and the tenant may or may not be evicted depending on whether or not the landlord can prove their case. But basically now I want to talk a little bit to tenants. A tenant should, upon receipt of a notice that says you have X days to cure the notice, should act immediately. That period, 3-day period, which we just talked about how to calculate, is going to govern. So you need to make sure you're taking action right away, because once the cure period is up, basically the landlord can say, I don't care that you mowed the lawn on the 5th day. I told you had 3 days. You didn't do it within 3 days. I'm proceeding to eviction. Now, maybe what we're talking about is mowing. Maybe the tenant and the landlord should talk. But nonetheless, if you have a cure, you need to make sure you're doing the cure within the time period. So if you you're given a rent notice that says you have 3 days to pay $1,000 for rent, you need to make sure you're going to the person designated by the landlord as the person to receive rent within those 3 days, not afterwards. If you try to pay it 10 days late, the landlord has every right to say, no, I will not accept the payment. You're going to be evicted. So again, the issue is going to be if you tried to cure within those 3 days. If you try to cure within 3 days, the landlord has to accept the payment within those 3 days. If you receive a notice that says you are in default with respect to the use of the property, you cannot use the property to store items for a business. If that's the violation, if you're looking around the house and you're not sure what you're supposed to do, contact the landlord. Say, I don't know what it is you want me to remove. And you can deny at that point saying you've got storing items. And if they say what we see is boxes that say that you've got multiple boxes stacked up, we believe those are for a business, you need to remove them. But ask the questions, find out what the landlord wants. Don't ask 10 days later if you're given a 3-day notice. So again, ask if necessary. We have gone through a number of new laws and changes to the landlord-tenant law today. If you need some help with your rental agreements. We can help you do that. We can help you create terms that make sense. What you have to know is that with the rental agreements, that law dictates certain things that can and cannot be in a rental agreement. So within our means, we can help you prepare a rental agreement that can be enforced with terms that are understandable. We can help you with the notices. We can help you with the eviction process if you need it. Now, our law firm, Copenbarger and Associates, Copenbarger and Copenbarger LLP, we've been open since 1979. We've taken on another couple of attorneys, so we're at least at 14 attorneys full-time. We've got counsel who are on counsel. We have a number of CPAs that work with us. We have over 350 years of combined experience. Many of our attorneys who handle the estate planning and the estate administration, they have advanced degrees in tax. We can meet with you via in-person meetings in our 8 locations, or we can handle Zoom meetings as easy as we can, in-person meetings. And we are available to help you. And here's our voicemails, telephone number, our website, but social media is one of the best ways to get a hold of us. And I'm going to just double check to see if we have any additional questions. I see no additional questions. So at this point in time, I'm going to conclude the webinar.